Hello guys, you are here.
Hello, ma'am.
Hello, ma'am.
Hello, ma'am.
How are you today? How are you, Fina? Has everything been all right? Like yesterday I heard that you've got some condition with your aunt. How's that?
Alhamdulillah, udah sih, ma'am. Dan untungnya di sana cuma 3 hari, jadi hari ini hari terakhir.
Oh, so it's not in Yogyakarta. Where is it?
Di Jogja, ma'am. Cuman kan karena my own tuh nggak berkeluarga gitu loh, ma'am. Jadi kami nyepetin jadi 3 hari aja, nggak 7 harian gitu.
I got it. Yeah, I'm so sorry for your loss, and may her rest in peace, and just be strong for you and your family. Yeah,
Thank you, ma'am.
you're welcome. What about the others? How are you all? Ima, Sakti, you great
Alhamdulillah.
with everything happened yesterday.
Tepar, ma'am.
We have one last round left on Thursday. Yeah, probably some of your friends wants to watch them. Like there would be a competition with Sakti and Fina. Yeah, Fina and Sakti would compete in the global round, and it would be the last round for the preliminary round on Thursday. If you guys want to see it, then I think we can open the Zoom meeting or whatever. Okay, what about the others like Krishna and Desi, and we have Rotno as well, and we have Adelson. Yeah, I've put your name on the list in the Google form, so I think you can start to fill the attendance list by the Google form. So yeah, I think you can already fill the form.
Yes, good afternoon, ma'am, and thank you very much. Yes, I have done to see that, and is working now.
Sorry?
Is working now. I'm enter the Google form.
Yeah. It's okay now. So yeah.
Yes.
The link is already in the description, in the group description, so you can just open the link and you can enter your student number, your name, and then the screenshot of this meeting, and yeah, whatever in it, so you can just fill it.
Yes. Thank you very much, ma'am.
You're welcome. Krishna, Ratno, what about the PKM things? Have you got some review?
Okay, now, so yeah,
Sorry, I cannot hear your voice. I mean, it's a little bit crowd.
belum ada email, ma'am, belum dapat.
Okay. Okay, well, yeah, those are all some, some activities of your friends outside the class. But I haven't seen Yusrael. Is Yusrael still in this class?
I guess he permit, ma'am, because the before this class we have class, and he asked for permit because he wants to submit the file for the police. Police, yeah.
Oh, yeah.
Akpol gitu, ma'am.
Oh, yeah, I see. Yeah. So he won't be present for today's class, yeah. Because I see that he didn't submit the assignment as well. Probably for some matters he didn't submit it, but it's okay. And I already have, I think it's most of you sent the assignment already, and that's the thing we'd like to discuss for today's meeting. It's yeah. It's Adilson, you already submitted directly to me. So I haven't seen the assignment from Muhammad Ada Umar and Yusril. Is Umar here? Umar? Mas Umar? Mas Muhammad Ada? Hello? He didn't respond. It's yeah, I don't know. I don't really know exactly whether it's whether Mas Umar is really taking the international program class, but if yes, then it's okay. Just please join us. But still, I'm waiting for your assignment if you want to still joining this class as well. So yeah, so this is the thing we're going to discuss about investigation. So in last week, I already asked you to submit some summary of your reading in the article. Yeah, in this article, right? About investigation. Can someone please tell me, based on your research in this article, about what is investigation? Or probably you have your own conclusion about what is investigation after you guys having research or reading this material or reading this article. So what do you think what is investigation? Can anyone tell me? No? Nobody? Okay, I'm gonna start with Fina's assignment. She said that investigation is process of solving problems with thinking skills. A process of solving problems with thinking skills, and in a case is a settlement to provide answers to questions that arise, such as proving a violation of law uh, in case committed by suspect. So this would be more on the criminal matter, like proving violation. And that investigation is carried out with critical thinking in seeing all the possibilities that occurs and all the answers arise. The investigators must critically assess all the information they encounter and so on. So, Fina, are you here?
Yeah, ma'am.
Yeah. So, can you explain me with your languages, like, what do you think investigation in Indonesia, or how investigation would apply in Indonesian law with your definition?
In my opinion, ma'am, investigation is just like we in case like either the civil case or the criminal case, investigation is a process to make sure that there is a like there is a violation of law. I think like that, ma'am. And in investigation, we it's also a process to get some evidence, I think.
To make sure there is a violation
Yeah,
and to to
provide
find the evidence.
yeah, to find the evidence.
Okay. So final state investigation is the process to make sure whether there is a violation or not, and the process to find out some evidence to prove that there has been a violation. That's what FINA said. What about Ambar? Ambar, could you explain me based on um, your assignment about evidence? Sorry, about investigation. Oh, Amber has just arrived. I'm sorry. So not Amber. Melly. Melly is here. Melly. Melly is not responding. And Krishna. Krishna, I want to hear your voice. Please enlighten me about what do you think investigation is and how investigation would apply in Indonesian law. What do you think?
Um, Actually, it's still relating with my assignment that I've been read some of journals, and I found the best one, I think, that relates to investigation, that said investigation in civil law, it can be used to prove the arguments, I guess, and to raise the plaintiff in terms of the required the proof from the plaintiff man. And also like wise for us for the investigation, however, for the controls of goods does not need to prove, and that uh, the entitled to said goods, I think it what else? I guess it can be said that parties with the evidence. So investigation purpose just not just something to find the evidence in balance or appropriate manner. That's it, ma'am. That's based on what I've been read.
Okay, thank you. So if I recall your explanation, then you say that investigation is mostly on how we try to find the truth. Is that correct?
Yes, ma'am. Exactly.
Yeah, find the truth and probably finding the evidence as well. Yeah. Okay. Thank you, Krishna. Okay. I think two is
You're
enough. So
welcome.
yeah. I think at least you guys already read my material that I gave you last week about investigation, and the material that I gave to you is actually based on the criminal law perspective, and in Bahasa you mostly hear it as penyidikan. Have you ever heard penyidikan or probably penyelidikan? Those two
Yes, ma'am.
activities or steps which is taken by the police are both included as an investigation action or in or as something we call as investigation. But in the term investigation is supposed to be a broader term, like it's very broad. You can classify some activities not only in a criminal field, but in other than criminal law fields, such as in civil law, you can also conduct a certain kind of investigation because as you guys already write down in your assignments, that it says that investigation is actually an activity to find some relevant issues, to find some relevant information, to collect data and to examine some data, to find the truth, to find the information about certain issues, certain related issues to the case. And to find out this information, then you need to have a preliminary, let's say a preliminary data or preliminary information. For instance, you guys are facing a civil law case, facing any civil law case, or civil law case which involve a tort. You guys know tort, T-O-R-T. What is tort? Tort in bahasa is perbuatan melawan hukum, if you guys know it. So tort is actually perbuatan melawan hukum. So one day you guys are facing a case with a tort issue, like someone coming to you and then they tell a story that somebody already conduct a tort and it causes loss to this one who consult to you, and then he asked you this your client asked you to help him, to assist him, to file a petition, towards those someone, let's say his C. So the one who coming to you is A. So A coming to you and then ask you to file a petition against the C. And he told the story about the facts, the relevant facts, and then probably he did have some evidences. However, after you guys trying to make analysis to form your petition, you feel that there is something wrong, or probably there are some evidences that, or probably the relevant facts are lack of evidences or lack of legal explanation on that or legal relation on that. So in this case, you're trying to find out whether this relevant facts is actually uh, bear a certain legal relation that make this A can have a legal standing to issue the C. So that would be part of one of the investigation, because you're trying to find out data and you're trying to find out information. Let's say, for instance, the case is about land, the ownership of the land. And then A is only having one piece of paper that, as you guys already read the paper, it doesn't have any legal legal force. It does not legally binding towards it's not legally binding towards both the A or the C, or probably not having any legal power in regards to the case. And then you need to find out, you can find a certain documents in, for instance, in BPN, Badan Pertanahan Negara, because it's the body who manage the land ownership. Or probably you can find some data, you can request some data in your in the government, in the level of regency, for instance, or probably in the level of the the village, like something like that. So investigation is not only covers in the criminal activity or criminal issue, but it covers in a very broader area. But the most important matter is that investigation is something, is an activity to find out the information, the correct information, of course, and to collect data. My explanation before was just one of the examples um, of investigation, but there are many kinds of activities that could be included as investigation. And I believe that the article I gave to you is quietly on the background of the common law system, which is in some condition it's different with what happens in Indonesia. And therefore I asked you for the second question is, how would you link, or how would you let's say explain on the investigation in Indonesian civil law system? Yeah, and some of you already answer as well, that you say in civil law is, yeah, it is mostly regulated in the criminal law. So the most activity that is regulated under the law about investigation is concerning the criminal law. But it doesn't mean that only in criminal law we have an investigation activity. So that is my opening statement about investigation. Some says as well, like what Sakti did. She said that in probably in HIR and in RV, you mentioned that there is a local checks or local examination. But I believe that this kind of local checks and local examination is what uh, is an activity which is conducted by judge. And if you can say that, let's say examination um, as the in bahasa as pemeriksaan, because examination has so many meanings. But when I say examination for now is pemeriksaan in the court. It's a court hearing. It's a hearing process, like when the judge try to hear the arguments from both sides. It's examination. um some say it could be part of investigation, because at that time the judges are trying to find out the truth, or the judges are trying to find out who is actually wrong and who is actually um correct, or is there any crime, or probably is there any violation of law. Yeah, so those are some questions would arise in examination, which is conducted by judge. But uh investigation that we're going to talk about with is not that kind of examination, because is not that kind of investigation, I'm sorry. So we're going to discuss about investigation is on the field of investigation conducted by probably by government body like police. And then we'd like to discuss investigation which is conducted, let's say, by an advocate, because an advocate or lawyer also could conduct an investigation, as they need as well to find some data or information, just like my example previously. And it's varied. Oh yeah, as I think it's as Krishna and or probably some of you or also mentioned in your assignment, that investigation also trying to find out um, the proof, right? Yeah, so on that matter, I think we need also to know what are the evidences, both in criminal law and in civil law or in private law, because investigation is very related to something like we call as evidence or the proof. So that's until now. Is there any question or probably an additional explanation about investigation and investigation in Indonesia? No? Krishna or Ima or Vina? Muhammad ada Umar?
For me, not yet, ma'am. I just take a look uh, your explanation.
Okay, thank you. Okay, this one from Amber. Yeah, Amber did it very clear. Yeah, like Amber did it clear, like in terms of both also have the same end objective, which is critical incident response, interpretation criminal law, and reconstitutional violation. Yeah, it's in a crime things. Witness assessment, interviews, suspicion of interrogation, and then preparation, documentation of cases, and then both have almost same institutional. Okay, yeah. Well, basically, again, I said that investigation could be conducted by the lawyer, the police, and then the judges. So it's not just limited to investigation which is conducted by the police, as in bahasa term is penyidikan. Because penyidikan in English, somehow people translate it to investigation. But the term investigation itself, it has a broader meaning, but because there is no clear or specific translation of penyidikan or penyelidikan, so somehow they use a police investigation to to translate penyidikan or penyelidikan, because penyelidikan and penyidikan is something is investigation which only police can conduct. So yeah. Okay, that's my opening statement. And then the next thing that I'm going to discuss is about, mostly people will combine between investigation and research. So mostly the sentence is investigasi dan penelitian in bahasa, or investigation and research, or research and investigation. What do you think, whether investigation and research are both a similar words, or probably they have different definition between investigation and research? What do you think? Any idea? About research and investigation, some people would say it as well, it's just a similar, alike, but some also say that it's actually different, different words. I actually ever joined or participated in a legal course, and one of the session is discussing about research and investigation, and I'm going to show you about it, about this research and investigation which they did give to us as the participants. But they put this specific field is in legal, because there might be not only in legal. So as I say before, yeah, investigation is very broad, and investigation is not only limited to legal field as well. It also covers more than that. It could covers like in accountant and in management, in whatever it is. So investigation is very broad. And then there's also the term research. So yeah. So here are some material from Budijaya Institute, which I've ever joined or participated in that course. And one of the session also discussing about what is legal and investigative research. So here, the 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 speaker said that she differentiated because it was a woman. Yeah, she differentiated between legal research and investigative research. So legal research is a search for authority that can be applied to a given set of facts and issues. So it's a research which can be conducted by anyone and trying to search for uh, search information towards authority, which is related to some set of facts or issues. And then there is investigative research, which is a search intended to discover and obtain facts, supporting documents, and hidden or obscure information, which can build a more comprehensive picture of the issue under investigation. So under this sentences, can you take a conclusion on what actually the differentiate the difference between legal research and investigative research based on this uh, sentences? What do you think? Ima, any idea?
Yes, ma'am. Sorry,
Advocacy, please.
all right. I got it. So first of all, research in the legal something, the legal case or legal by the rule of law, we're going to find out the information. Some case, how the case topic is. I mean, it's not only in the criminal, but both of the case. Going to the civil law, maybe. Maybe going
Yeah,
to
yeah.
anywhere I'm breaking law. So we buy the ourselves to find out how the information is the we call the research by based on the legal binding. So in different with the investigation, we just waiting for somehow the act. So we talk and something we feel that get hiding in the one case. So we talk and we find out how can you talk that very much unclearly or the fact about the case. So just like this in there for me.
Okay. So are you saying that having an investigation is like, yeah, uh, meeting to someone and then asking for something, and then like this something is related to the facts of the case and so on. Is that correct?
Yes. Research is we won't find out that information. So
Yeah.
investigation is let's talk by the talk. So I gonna ask something that go hidden from this case, and I'm not find out that in the information the case, but we can ask everything, whatever you in the case that. But there is something in the one case you hiding from this case, like this man.
Yeah, exactly. Exactly, that's what I'm trying to explain, which is, yeah, investigations like you're trying to find out, and how to find it out. Yeah, you need to ask, you need to, you know, having a research or observation or whatever the method is, but the most important is that investigative or investigation is like you're trying to find fact. Yeah, thank you, Edelson.
You're
Uh,
welcome, ma'am.
yeah. What about the others? Yeah, any, any idea again, or do you guys want to give your opinion about what is legal investigative and what is what is legal research and what is investigative research, and what is the difference between both, as I already show you some sentences about legal research and investigative research. Any idea before I explain? Okay, no. So basically, investigative research is something more um, specific. So it has a specific purpose, which is different. Somehow it's different with legal research. Legal research is way more common, general, like it is way more general. I would say that when you guys are in your last semester and you guys have to uh, make a thesis as your final assignment to graduate from this university, I think you have to conduct research, and the research should be a legal research, and that would be a broader meaning. That would be why a research is broader rather than investigation, because investigation, it has a very specific purpose. Like, what is the purpose of conducting this investigation? Because somehow having an investigation is like you guys trying to find facts, a set of facts, and then you guys finding documents, or trying to find a hidden information as well. So uh, um and in investigation, sometimes it involves a certain issue, which is the real issue, and the legal research is way more broader, because the issue is way broad, and somehow the legal research, which is if we're trying to link it to academical research, then the issue has already passed. So what you guys can choose to be the object of the research is mostly some judge decision, or mostly some the rules or regulation, and some other things that already passed, and maybe already have a legal power or legal binding power. So that's different. So investigation or investigative research is way more specific, because it has a specific purpose. And here are some objectives. I believe that we actually have to discuss about advocacy in this semester based on our syllabi, but I think I'm going to change it. So today we would like to finish talking about the investigation, and the next meeting, the two next meeting, we'll discuss about advocacy, and the two next meeting before midterm would like to have such kind of um, you know um, practical method thing. So I'm going to make a role play, because in the last two meeting, or one of them would be we will conduct this kind of virtual meeting, and I want you guys to play a role to do a practice of how to conduct investigation and how to conduct advocacy. So now we move to the theoretical framework again. What's the objective or the main purpose of conducting an investigation? It is, of course, to obtain the comprehensive understanding of the issue or situation. Of course, to get a full picture about something. Like my example before, when someone, a client A, meet you and ask you to be your lawyer to file the petition towards C, but his explanation about the relevant facts are not enough, and the evidences or the documents he gave are not enough as well. So in this case, you guys need a very full picture, way more full picture. I've ever I've ever met a client back in around 2018, and this client is asking me to assist him to take care of his land ownership somewhere in Purworejo. And then he only literally he only have his his memory that he says, I own this land. When back in time when I was a child, I grew up here, I grew up in this land, and then my father gave it to me when I was a teen, when I was teenager. But then when I was adult, I moved to Yogyakarta, and now I don't know how the land is already registered as someone else, which is C, let's say. So yeah, you can imagine that the information is very limited, is very general, and we have really no idea because we have no evidence at all. This is the private case. Yeah, this is a very this is a private case because it relates to the land. Yeah. And then he asked me, he asked my team to assist him to find out first to find out the land ownership or the land registration, like why it can be registered to someone else, whereas his father gave it to him back when he was in teenager. And then we went to Purworejo. And we find out, we asking someone, like starting from asking the neighbors of this land, trying to ask do you know who owned this land, or do you know who built the building here, or yeah. But the unique thing is, um because this client is already old, like I don't know, like 70 or 80 something. So he's already old, like 70 something. You can imagine 70 something when he was teenager would be back in, I don't know, in probably in 1960s. Yeah. So we have to coming back to 1960 to find out the witness who really know that this land is owned by my client, right? And then yeah, that is one of the techniques. So you have to choose the correct you have to choose the correct source, the correct subject to be your source of information. So that is one of the example. So you are trying to get a full picture of what happened or the issue of this thing. So this is one of the purpose And the second one is finding relevant legislations, precedents, information to given issues or situation. Yeah, finding relevant legislation, precedents, and information. Of course, relevant information is very important, and then relevant legislation as well is important. So you have to make sure at the very first time, what is your case? What is your issue? And what is the legal basis of your issue? Let's say in private law, again, I'm gonna give an example in private law. Yeah. Let's say the petition in private law, there are two legal bases of petition. First is based on the breach of contract, which is in Bahasa, it called as one prestasi. And then the second one, you have tort, which is in Bahasa is perbuatan melawan hukum. So if you want to file a petition, you have to make sure at the very first beginning that your case and relevant facts is exactly based on tort or breach of contract. So you have to decide it the very first time. In order you guys can decide which one would be your legal basis, you have to find out again at the very first beginning the relevant fact and uh, the full picture again. So the first thing, you have to know what happened. That's exactly you have to have at the very first beginning, and then based on that facts, based on that set of facts, you guys can decide which is this one should be based on breach of contract or tort. I'm gonna give an example like this. Have you guys ever known about the business entity, which gives a services of you guys can you know wait, what's the term in, it's like yeah, okay, it's like this. So a storage, like you guys have a motorbike, you guys are not in Yogyakarta, you are not from Yogyakarta, and then but you have bike here, your parents already sent to you the motorbike, and then someday you want to coming back from to, let's say, Sakti, where are you from?
Bengkulu, ma'am.
Okay, Bengkulu. So one day, Sakti wants, it's Sakti, yeah. Sakti is not from Jogja, she's from Bengkulu, but let's say she lived in Yogyakarta for having the course in OAD, and then one day she wants to come back to Bengkulu, but she doesn't want to take care of the motorbike because it won't be long enough. So she put her motorbike in a motorbike storage, like in Bahasa you would hear it as penitipan sepeda motor, for a moment, let's say for 3 days, because she doesn't have anyone in her dormitory, no one in her class. So yeah, she put her motorbike in the storage, and then firstly it was based on the agreement between Sakti and the owner of this motorbike storage, right? Sakti said that after 3 days I will coming back and I will take my motorbike again. So you should take care of it. And then in this regard, Sakti should pay some amount of money to this motorbike storage, because this storage, the owner already take care of Sakti's motorbike. So that was based on agreement. However, this is amit ya. This is amit ya. Let's say on the first day or the second day, the owner with the with the criminal intention trying to embezzle Sakti's motorbike. Like let's say the owner is she lent this motorbike to her friend, meminjamkan to her friend. And then after 3 days, after the third day, Sakti came back and then trying to take her motorbike is not there. And then the owner of the storage said that, oh, I'm sorry, it was stolen. But the fact is actually he lent it to someone else on purpose. It was embezzlement. But then if Sakti want to sue or want to file a petition towards this guy, towards this girl, towards the owner of the storage, in which legal basis, whether it should be on the basis of breach of contract or on the basis of tort. Because at the very first beginning, it was based on agreement. So it should be breach of contract, right? But the later, there was a criminal intention, which is the girl, the owner, is trying to embezzle. Embezzle in bahasa is penggelapan. Menggelapkan, embezzle the bike. She actually has the authority, has the right to take care of the bike, but she misused the right or misused the authority and lent it to someone else. So which one is the basis? Now, to find out this condition, to find out the very full picture, to become the legal, to become the ground of analysis, to find which one is the legal basis, you have to conduct at least an investigation. So that is my example on why finding on why it stated relevant legislation, and then precedents as well as precedents, the legal, the judge's decision in the previous case. And the third one is have the sufficient information before making analysis, conclusion, or decision. Yeah, exactly, of course. So after you gain information, you have some information and data, and then you guys need to make a conclusion. Whether the conclusion is not only limited to whether you should file petition on which legal basis, but it is also involve the conclusion of whether whether the plaintiff has legal standing or not. Let's say in my previous case about the land ownership in Purworejo, at the end of the day, we found out that my client has no legal standing to file petition, because of he doesn't have any legal standing to file petition. So I did say to him that you have no legal standing, and if you trying to sue to the court, you will suffer loss, because the court will of course dismiss your case, or the court will of course uh, won't accept your case, because you have no legal standing on it. So yeah, that should be the purposes or the aims of having investigation, and this is one of an important steps to the lawyer or to anyone. And the next question is, okay, before going to this how to start, I want to recall you guys that one of the most important thing in having investigation is you guys find out the evidences, right? It was your statement as well, like Krishna's statement, Fina's statements about having about finding out some evidences, right? But do you guys remember what are the evidences in criminal law? Do you guys remember? Sorry, what?
Saksi, ma'am.
Saksi. What is saksi in English?
I forgot, ma'am.
Witnesses.
Yes, witnesses. In criminal, so we have witness, and then who is witness? Who is witness? Who can be classified as witness? Who can be classified?
Who's watching or who's see any of the criminal story?
Only watching?
I mean the who's watching the two criminal doing the crime. I mean something Robert maybe or something Robert bank or killed someone who's watching in the I think that he can see
Okay.
that
Yeah. Okay, I get it. Is it only watching? Is witness only watching is enough?
No.
What else? Other than watching. So witness should be the one who watch and then
Explain the cases.
explain based on what?
Di kejadian, I guess, ma'am.
Explain or experience?
Explain.
Explain means menjelaskan. Is that correct? Is that what you mean?
Yes, ma'am. Explain, menjelaskan.
Okay, thank you, Krishna. Anyone else? Who is witness? Have you guys ever read in your criminal procedural law about witness? Have you guys ever discussed this in criminal procedural law?
yes, ma'am. One more thing again about the witness. Witnesses is to gather information about all the crimes doing that in the format, not only watching, but he talks it about that all information he gathered, and he can give that one evidence or more evidence he know it or they know it about the information that happened in the crime or it happened in the crime doing
Okay.
information more or explain like witness say or any words about the crime did it.
Do you guys think? Okay, thank you, Adelson. What about the third party? Can the third party, let's say, who hear some information from someone else, could be categorized as witness? So, in common law system, it is said as hearsay. Hearsay. Sorry. Hearsay evidence. Who is this one is witness who who only hear some story or information from the party, let's say. Can this one be the witness, can be categorized as witness? What do you think?
Ma'am, I want to ask, hearsay evidence is if the person hear about the case from the person who in that case or other witness.
So they can be a witness in that case. They only hear from party or from any other witness. They can be the witness.
I think
All right,
yes, ma'am.
All right, ma'am. Sorry, Tina, I interrupt you. I'm sorry. Hearsay I think the one part of me is if the hearsay is true enough, or we're looking for the research, the information is true, we say that witnesses, but the one part only go to those parts is not true enough. I think that we don't say that it's witnesses or evidence. We can do it that some 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 information, or I think that there's two information. It's not the only one that is a two part. If there one part we going to hearsay is a true information, or we gathered the crime. Is there one example? And two example, we don't gather the crime, or we just lost them. I think it's not fair to say that witnesses or evidence like this, man, for me.
Okay. Thank you, Adelson and Fina. So before going to hearsay, I'm gonna recall you guys. I'm gonna remind you in the criminal procedural law class that there are some evidences in criminal law, and one of them is witness. Witness is someone who watch, listen, and experience. So these three relevant activity must be a cumulative activity of the witness. So witness can not only the one who watch, because if they're watching but they didn't listen, so probably the information would not be in a full story, and a full, let's say, in a full picture. But then watching and listen only are not enough, because watching and listen, just watching and listen could be regarded as hearsay, because probably they just watch and they listened some story, but they did not experience. So yeah, this is what witness says. So that's why somehow it is not easy of. Okay, what happens? Sorry. So somehow this is not that it's not that it's not easy, but it requires some investigation to find out who is the witness, and whether the witness is qualified as the witness. Yeah, I'm sorry, it's my baby. And then other than witness, okay, before moving, what about hearsay? In some case, hearsay could be regarded as witness in only in some specific case. Yeah. Only in some specific case. Let's say in civil case, in the divorce case. In a divorce case, somehow the one who is the hearsay witness could be the witness of the divorce case, because divorce is very private, like it is it is a case with a very private issue, because it's about a domestic issue between husband and wife, and it's very rare that people outside of this family know about what happened. So that's why somehow hearsay witness is acceptable in the divorce case. But other than divorce, it's very rare. It's a little bit hard, even though the court would hear their statements. Probably it won't be that it won't be that significant to be the analyzed, to be the ground of analysis. This condition is a little bit different with the condition in other common law system, where in common law system mostly they are you know somehow accepting this hearsay. Okay, so thank you the explanation of Fina and Edelson before. And then other than witness, what else in criminal law? After witness, what else? Anyone?
The document.
The documents? What kind of documents?
Um, sorry, ma'am. Maybe ahli. Ahli dulu.
Ahli. What is ahli in English?
Um, legal research. I don't know.
Legal what?
Legal expert, Sakti
Legal
mean.
expert. Does it have to be legal? Does it have to be legal expert, ahli hukum,
Expert,
or just an expert?
just
Expert,
expert maybe, ma'am.
just expert. So it means
Yes.
that it doesn't have to be legal one. Yes, because have you guys ever watched the um Jessica murder case? A Jessica murder case, which was Mirna was poisoned by something in her coffee. Yeah, and then one of the experts is doctor, right? So yeah, the expert doesn't have to be legal from legal field. And then what else? As what Sakti said before, documents, but what kind of documents? Le? It's what? A letter or letters. Surat-surat, which is any relevant letters related to the case. If the case is about the drugs, then probably the letters which explain that the thing which is used by the defendant is containing drugs. So there are so many so many products of drugs which it has many kind of names like tembakau gorilla. Have you ever heard gorilla? It's a gorilla, and then it contains uh, I don't know. It's a bihaminacha or something, which is it is classified as drug. So probably the letter could be that letter which explain that. So letters would be so many letters, and then after letter, what else?
Objects,
What is objects?
like benda gitu.
What kind of object?
The object that we find in the cases places, for example, like if there is a murder and the police find the knife or around the places that uh, terjadi murder, so it can be used as the objects
Okay,
and for
so
the evidence.
like goods, yeah, like any goods or yeah. Uh, can you find it in the criminal procedural law that there is an object as the legal, as the evidence in Kitab Undang-Undang Hukum Acara Perdata? Is there any evidence mention object as an evidence? Okay. Usually it is goods. It is called as good or tool, like a tool where the defendant used for conducting something, and mostly the tool it requires an explanation, or it requires a supporting other evidence. So it cannot be just a tool itself, but there should be a certain kind of supporting evidence, which is could be witness. So witness would be asked, like, do you know this tool, and how do you know about the defendant using the tool and whatever. So the tool itself, it should be has any relation, but the relation could be part of the fourth evidence, which is the uh, it's I'm not sure the translation in English, but the translation in Bahasa is this one. It's guidance, or the in Bahasa is petunjuk, which is it should be a form, a set of relation between the letter, and then the witness statements, or any tools which is related to witness statements. So yeah, and then the fourth one is the defendant statement. Yeah, so this one based on KUHAP, or criminal procedural law in Indonesia. It might be varied in other country, so probably it would be different in Adelson's country. In I don't know, in Brazil or in Timor, it would be different. This is based on their own criminal law, procedural law. And what about the witness? What about the evidence in civil law? It's in criminal law, and this one in civil law. What are the evidences? The first one is,
Witnesses.
sorry, what? Sakti said
Letter.
witness.
Sakti.
Krishna said letter, and Sakti said witness.
Yes.
Do you guys remember that I said the most important in civil procedural law is to find the formal truth or formal issue, which is based on some documents or legal or any written documents, or letters. So that's why in the civil law, the very first evidence should be filed to the judges, should be that the parties should give to the judges is letter. And then the second one after the letter, it is witness. So letter is somehow higher, or probably more preferable rather than witness. But still, in civil law cases, it requires witnesses, of course, still. But letters would be the first, and then witness. And then the third one is,
Persangkaan tuh apa, Mem? Persangkaan.
persangkaan is like allegation, or allegation of the judges.
Maybe it's one of the evidence in civil.
Okay, it's a judge allegation. But this would be the last one. The third one is confession from the parties. So because of this is a civil case, this involve a private relation between one party to another party. The confessions of the parties would be one of the evidences. Like whether the parties confess that there has been a legal relation, or probably there has been a relevant fact happened or whatever. So the confession would be one of the evidences, and should be one of the basis of legal analysis from the judge. And then the next one is oath. Oath from the parties. Oath, oath, right? Sumpah from the parties, like when they are really taking the oath for something or not really happen, for instance. Yeah, those are the oath. Would be also one of the, but I rarely seem I rarely see the oath as the evidence in the reality. I don't know, maybe maybe somehow the judge will use oath, but because oath would be very, would be a very let's say apa ya, I would not say it's as cheesy, but somehow oath is difficult to propose an oath as the evidence is way more difficult rather than the other, rather than the other evidences, because it is an oath from the parties, let's say. So, and the last one is judge allegation. Yeah, like the judge have an allegation towards the parties, but the allegation, of course, should be based on the relevant grounds, relevant reason. Yeah. So those are the evidences. These evidences are related evidences that you have to find out, or it's not that you have to find out, but those are something that you have to consider to be present in your case, because in criminal law you guys need a minimum of two evidence, right? Two evidence, that's the rule in criminal law. And at least you need two evidences, which mostly they translated to at least needs two witnesses. As well as in civil law, usually judges will ask you to provide at least two witnesses to prove your petition, to prove your statement of the petition or lawsuit. So those are the evidences. And how to find out the information and data of the evidences, then you would conduct investigation. So that is one of the importance of investigation. And then the next is how to start investigation. Yeah, you have to make a work plan. And then this one is a chase chart. It's like when you are working a team or you're working by yourself, you have to make this like you draw a chart. You really draw a chart to make sure on what is the relation between one and another party, and then you try to find what is the scope of the issue, what is the field of the issue. And by using the chase chart, it's a case chart. By using a case chart, it would be easier for you to define and to classify. And then identify the issues. What are the issues that you're going to find out? And then, first finding the issue, and then the second one, the third is finding the issue, and the fourth one is finding the issue which you need to clarify or you need to obtain. And then the last one is identify the source of information, as I said before, as my example before, that my client is 70 years old and his story is we're going to back in 1960s, and we have to find the source of information that is correct and relevant. So we need to find out some old people, which is, yeah, let's say already 60 or 70s, who know at least the issue that we are going to find out. And then This one, like, yeah, some tips, and we have some other more. Wow, there are so many. Like tips, yeah, don't be panic. There is no one right way. So you can also there is not only one way to find out something. There are so many ways, and you guys are living in the technology or digital era that you can find some information not only by having an interview or not only obtain information from someone face to face, but you can also find information from the website or whatever. And then you guys have to find everything which is efficiently in terms of time, and that's therefore you have to make it in a smart way. What does it mean by smart? Means that you need to think the way to get your information by the limited time. So yeah, that's the thing. And then yeah, this is tool sources, like whatever could be some could be one of these sources. So it's not only the, as I said before, meeting with someone face to face. So I think uh what time is it? What was the what is our last schedule? I mean, until what time? It's 2:10.
Until 10, ma'am.
Okay. Now, is there any question until now? Any question? No?
Ma'am,
Yeah, please, Sakti.
in civil procedure,
Mhm.
expert also in evidence for one of the evidence in civil procedure. Expert.
Uh, have you ever? Sorry. Are you asking or you're telling me?
Uh, Asking maybe, ma'am.
Okay. You guys can open your HIR or RVG. HIR is Indonesian source of law in regards to the uh, civil procedural law, HIR or RBG. It says that the it says that the evidences of civil law, civil procedural law, are these five evidence that we already discussed. However, yes, in some issue, at some issue, it is okay for the parties to propose the witness, expert, sorry, to propose the expert to be one of the evidence, or probably just for giving a supporting analysis about certain matter. But under this HIR and RBG, it was not clearly stated about the expert. It is different with in criminal law procedure, where criminal law procedure in criminal law procedure, it is clearly mentioned that ahli or expert is one of the evidences. But in civil law, it is not clearly stated. But again, in the fact, in reality, somehow parties can propose for expert to be present in the court to give their explanation about the issue. As I've ever I've ever have a case in Makassar, and then the case was about land ownership again, and then the case was quite big, and then we proposed for the witness, for the expert to be present and to give a clear explanation about something like land ownership. So it's very possible. That's Sakti, my answer. Any
Okay,
other
thank you,
question?
ma'am.
Any more question from the other? I think if you guys have no more questions, we can discuss about this would be interesting to do you want to discuss this next week or we move to advocacy? What do you think? We still discuss investigation or we move to advocacy on the fourth meeting? Because I want us to have the, you know, the practical things in the two last meeting, in the 6th and 7th meeting, for us to having a role play. Yeah, that's gonna be so great. I think we can yeah, we can still discuss this and probably just some little information about advocacy. Let's see next week. Okay, that's all from me. Thank you very much for your attention and your feedback, your questions, and your whatever it is of the contribution. I'd love to hear your statement soon in the next meeting as well. But don't forget to fill the attendance list in the Google form. And then I think that's all. Thank you. And if you have any question, just please mention your question in the group. And